All right, so we'll go on the record now. This is case number 15-53547 DS, Courtney Jane Rotier versus Stephen Michael Phillips. Plaintiff is represented by Mark Miller. And this is a motion for the appointment of next friend for the minor child, and a motion to do a name change. So let's take up the petition for the appointment of the next friend first. You can go ahead, Mr. Miller.
All right, thanks, Judge. So the minor in this, the child that we are requesting to change the surname of in this case, his name is Kelvin Patrick Phillips. He is a minor. He's about 7.5 years old. So pursuant to the statute, as he's less than 14 years old, we're asking that an next friend be appointed on behalf of the child. The minor child does not have a guardian that's appointed for him at this point, and we believe pursuant to MCR 2.201 subsection E, subsection 1, subsection E, that the appointment would be necessary. My client, as the child's mother, has petitioned for to be nominated as the child's best friend. And she also was the one that initiated the motion to change surname of minor child. We believe she's a competent person to be appointed as next friend for the minor child. She also possesses not only sole physical custody, but sole legal custody of the minor child. So accordingly, Your Honor, we would ask that my client be appointed as the next friend for the minor child, Kelvin Patrick Phillips.
All right. The court has reviewed the pleading, and I do find that the petitioner is an appropriate person to be appointed the next friend for the minor child, and the court does so appoint her. So then that moves on to the motion for the change of the surname of the minor child. And you can go forward with that motion, Mr. Miller. I don't know if you wanted to make any introductory remarks, if you wanted to swear your client in, how you wanted to handle that.
Yeah, Judge, if I could just basically kind of give a brief, summary for purposes of the record, and then I'll have my client sworn under oath just to kind of ask her questions pursuant to those items that are required underneath the statute.
Okay.
Your Honor, as you know, we've been here a couple of times due to some scheduling issues. I think on 2 of the occasions we were here, the prison was supposed to have Mr. Phillips, the defendant in this matter, Stephen Phillips, available, and he was not available. So as a result, this matter has been adjourned a couple of times. We have filed our motion to change surname of the minor child, and we noticed that each time, as we discussed at the beginning of this, I'm not sure if we were on the record or not, but I filed, my office filed a proof of service. Then on January 20th, 2021, we filed a re-notice of our motion to change surname of minor child, along with the petition for appointment of next friend, notice of hearing, consent to appointment of Courtney J. Rotier as next friend, and the circuit court Zoom instructions, along with the proof of services to the parole officer by the name of Derek Bond, and Mr. Bond is the parole officer for Mr. Phillips. And as we sent that to Mr. Bond via 2 different methods. Number 1, we sent it via U.S. mail, regular mail at 15950 East 12 Mile Road, Roseville, Michigan 48066. There was proper prepaid postage on that. We also sent the same documents to Mr. Bond's email at bond1@michigan.gov. We did not hear any, we did not receive the mailing back. We did not receive a rejection email back from the email. We also sent these documents, the same documents, to Mr. Phillips, to the prison that he was incarcerated at prior to his release date. Again, we believe that he was released from prison on or around December 29th. And that was confirmed by Mr. Bond to my staff that Mr. Phillips was out of prison at that point, and that conversation was back in January. So, Your Honor, I think, I don't want to belabor that. We've, I think the particular statute at, at play in this case is MCL 711.1 with regard to the name change of the minor child. One of the issues that the court has kind of addressed previously was that concern about the parties being married or consent being given, we have pointed out that, the provisions under both MCL 711.1 subsection 5 along with subsection 6 of the same statute indicate and or being, I think, the operative word, if only one legal parent available to give consent. In this particular case, we have previously provided, I believe, to the court a copy of the order dated January 15, 2016 from the family court signed by Judge Dimkoff, indicating that my client was awarded both sole physical and sole legal custody of the minor child. As a result, we don't believe that Mr. Phillips would have proper standing to be able to give consent, because all legal decisions, whether they're educational, medical, legal, or what have you, my client has the sole authority pursuant to that January 15, 2016 order. Proceeding to paragraph subsection 7 indicates that the name change may go forward as long as notice is given to the non-custodial parent, which we believe, as I've just stated, has been properly given, is appropriate in either, and again, either is the operative word in the following circumstances. And letter A is if both of the following occur. Subsection I says, A subsection I says the other parent having the ability to support or assist in supporting the child has failed or neglected to provide regular and substantial support for the child, or if a support order has been entered, has failed to substantially comply with the order for 2 years or more before the filing of the petition. And then subsection I says the other parent having the ability to visit, contact, or communicate with the child has regularly and substantially failed or neglected to do so for 2 years or more before the filing of the petition. I know that the court obviously has read these pleadings previously today, so I guess I'll rest at that, and I would ask at this time to be able to swear my client in so I could take some brief testimony.
All right, would you raise your right hand, please, ma'am? Do you solemnly swear, oath, or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you're going to have to speak up a little bit. All right,
I
you
do.
go ahead, Mr. Miller.
Thank you, Your Honor. All right, Ms. Rotier, could you please state your full legal name for the record and spell your last?
Courtney Jane Rotier, Rotttier.
And how many children do you have?
1.
And what is his full legal name?
Calvin Patrick Phillips,
And can you spell his last name for the court?
Phillips.
And what is his date of birth?
8/2/2013.
And has it ever been established by any court as to the custody of your son, Kelvin?
Yes.
All right. And when was that established?
2016 by
Okay.
Judge Dimkoff.
All right. And who was awarded physical custody of Kelvin in 2016?
Myself.
All right. And does Mr. I don't know if I got ahead of myself, but who is Kelvin's father?
Stephen Phillips.
All right. And was Mr. Phillips awarded any form of custody in 2016 or of physical custody in 2016?
None.
All right. Was he provided for any parenting time in 2016?
No.
Okay. And then in 2016, did Judge Dimkoff enter an order with regard to legal custody of your son?
Yes.
And and who did the court award legal custody to?
Myself.
All right. Was that an award of sole legal custody?
Yes.
So no provision of legal custody was made to Mr. Phillips in 2016, correct?
Correct.
All right. Since that order was put in place back in 2016, has there been any subsequent orders with regard to your son, Mr. Phillips, and the physical and legal custody awards that were made back in 2016? Okay. So in 2016, you were awarded sole legal and sole physical custody, correct?
Correct.
Has that order been changed in any way, shape, or form with regard to that award of legal and physical custody?
No.
All right. So how old is your son right now?
7.5.
All right. And has Mr. Phillips ever had parenting time with your son?
No.
Okay. And has Mr. Phillips provided regular financial support to your son?
No.
Has he provided any kind of financial support to your son throughout his lifetime?
I've had 3 checks in 7 years.
All right. Can you tell the court when the first check was approximately?
It was 2016, maybe.
All right. And do you recall the approximate amount of that?
It was just over $1,000, I think.
All right. And do you know how you received that?
The Michigan disbursement unit.
Okay. And when would the second payment have been?
It was just before Christmas of 2018, I think,
And what would the approximate amount have been there?
about $1,200.
All right. And again, how did you receive that payment?
The MISBU.
And when was the third payment approximately?
Just the first week of January for $265.
All right. And again, how did you receive that?
Michigan disbursement.
So throughout the course of your child's 7.5 years on this earth, you've received 3 payments with regard to financial support from Mr. Phillips.
Yes.
All right. Now, Mr. Phillips has been incarcerated during the lifetime of your son, correct?
He has.
All right. Now, I'm going to back up here a little bit. When your son was born, were you and Mr. Phillips together at that time?
Yes.
All right. When did you and Mr. Phillips terminate your relationship?
Officially February 2014.
All right. So that would have been approximately 6 months or so after your son was born.
Yes.
All right. And were the two of you in the first 6 months of Kelvin's life, were the two of you together during that time, or tell the court what was going on during that time?
We were together when Calvin was born in August through September, October, and November. I left in November, and then we officially were done in February. So I moved back to Fremont in November.
All right. Now, did at some point subsequent to your relationship ending in February of 2014, did you at some point learn that Mr. Phillips had become incarcerated?
He was not.
Okay. But did you learn that he became incarcerated at some point?
Yes.
Okay. When did you learn that he became incarcerated?
A year and a half ago,
All
when
right.
he went in, when they notified me to stop child support.
Okay. And so from that point, so when he went into so when they went to terminate child support, that was about a year and a half ago, you said?
Yeah, I think so.
All right. So from the time that the two of you had split up in February of 2014 until that point, as far as you're aware, Mr. Phillips was not incarcerated, correct?
Correct.
All right. So that would have been a period of well in excess of 2 years that he could have contacted your son, correct?
Yes.
Did he contact your son during that time to receive any kind of parenting time?
He filed a motion for parenting time. It was probably in like 2016, right after the first child support check.
All right. So what happened at that motion for parenting time?
He was awarded parenting time by Michael Page. And in order for him to receive his parenting time, he was ordered to take a drug screening and parenting classes, which he never did any of those things. So it just was void.
All right. All right. So he never ended up having, he never received any parenting. Is that correct?
Right.
All right. Did you ever, have you, since the two of you separated back in February of 2014, have you ever received any written or verbal requests for parenting time besides that motion from Mr. Phillips?
No.
Have you and Mr. Phillips reconciled at any time since your relationship was terminated in February of 2014?
No.
Did you become aware at some point that Mr. Phillips' incarceration had ended?
I looked by myself on the Michigan Otis.
All right. And did that indicate to you that he was incarcerated?
It indicated that he was released on December 29th and on parole.
All right. Have you been contacted by Mr. Phillips since he's been released on parole?
No.
Have you been contacted by any family members, friends, or anyone else on behalf of Mr. Phillips since his release?
No.
Have you received any financial payments aside from what you've talked about from anyone besides Mr. Phillips on his behalf?
No.
I
have no further questions, Your Honor.
I have a couple questions. I was kind of thinking about something else, and you may have covered it. From the time, for the 2 years immediately preceding when you filed this petition for the name change, has Stephen Phillips had any visitation with your child?
No.
All right, for 2 years preceding the filing of this petition, has he contacted your child in any way?
No.
Has there been any communication with the child, like letters, phone calls, anything like that?
No, sir.
All right. That's all the questions that I had. Anything else, Mr. Miller?
Nothing other than just a brief closing, Your Honor.
Okay, go ahead, sir.
Your Honor, I think even despite Mr. Phillips' incarceration, even if we counted that time, there was no contact for 2 or more years. There was not regular or substantial support that was provided, which is what the statute requires during that time. And then if we look at that time, from the time that, the relationship was terminated, the parties didn't obviously see each other since that time, but the relationship was terminated in February of 2014, all the way up until about 1.5 years ago. There was absolutely zero contact from Mr. Phillips and the minor child. So we believe that portion of the statute is satisfied. And we also think that three payments over the course of this child's life in 7.5 years, even from the time the child was born up until the date of his recent incarceration 1.5 years ago, we believe we again demonstrate that Mr. Phillips has failed or neglected to provide regular and substantial support. Nor has he regularly and substantially, including he's also regularly and substantially failed or neglected to have 2 or more years of contact with the minor child during that point. Notice was properly given here several different times. He has never appeared. Notice was again given to him at the prison prior to his release, as well as via 2 different methods to his probation officer. And for those reasons, Your Honor, we think that we would request that the court grant the relief that we've asked in our motion to change surname of minor child.
All right. The court's going to take this case under advisement. I will issue an opinion, and I can tell you just generally what my issues are. Under subparagraph 7, 7A, both 1 and 2 have to be present. And what I'm looking at is the other parent, that would be Mr. Phillips. Within the 2 years preceding the filing of the petition, did he have the ability to support or assist in supporting the child? And if so, if he's had the ability, has he failed or neglected to provide regular and substantial support for the child? That's option number 1. Option number 2, if a support order has been entered, has he failed to substantially comply with the child support order, again, for 2 years or more before filing the petition? I think that is going to be problematic for this petition because if we're looking at 2 years prior to the petition, it's hard to say that someone who's in prison without knowing more would have the ability to provide support and assistance during that period of time. So you may fail on A1. A2, clearly he's had the ability to have some sort of contact or communication. I mean, you can send letters, you can do phone calls, you can do that sort of thing from prison. So I think clearly the testimony has established A2. It's just kind of a matter of, I guess, grammar. With number one, does the for 2 years or more before filing the petition, does that modify the child support provision only? Or does it relate back to the substantial support having the ability to do it? Because clearly there was a 2-year period when he wasn't incarcerated, where presumably he had the ability to do it, and he didn't. So that may be a way to accomplish this under subparagraph 7. But if that 2 years or more modifies either one of those two other options, then probably can't grant it on that. So that's just kind of my thought process there. I'll have to work through that issue. And then as to either 5 or 6, whether him being deprived of legal custody, does that give Ms. Rotier the unfettered authority to change the child's name? I don't know that. Could very well be possible, but I need to make sure on that. So I'm going to double check that issue. So, but the court will issue an opinion shortly on those matters, and we'll send it out when it's available.